In 2001, the Bush-Cheney administration started using those powers. On September 25, 2001, 2 weeks after 9/11, a deputy in the Justice Department's Office of Legal Counsel named John Yoo completed a secret memo that would lay out the powers the executive branch believed itself free to exercise in the coming war on terror. Mr. Yoo's secret memo asserted as fact that, quote, the president's powers include inherent executive powers that are unenumerated in the Constitution, among them a right to use military force as he saw fit, regardless of the views of Congress. And citing the unitary executive theory, Yoo wrote that Congress has no power to limit how the president went about defending the nation. We think it beyond question, Yoo wrote, that Congress cannot place any limits on the president's determination as to any terrorist threat, the amount of military force to be used in response, or the method, timing, or nature of that response, because these decisions under our Constitution are for the president alone to make. This is a vision, close quote, this is a vision for a commander-in-chief who exists above the rule of law as it has been traditionally understood in this country. It is also a view that runs counter to mainstream and traditional understandings of the Constitution. But it would not be long before the administration discovered opportunities to turn its aggressive theory into real-world action. Each time a problem arose, and many problems would arise in the weeks and months after 9/11, including in matters of surveillance, detention, and interrogation. Each time a problem arose, the inner circle of decision-makers at the White House looked at their options for solving that problem. And then they picked the solution that relied upon the greatest possible assertion of unilateral presidential power to bypass statutory and treaty constraints. By acting on their legal theories, they transformed them into historical precedents that future presidents will be able to cite when they, too, want to evade such a limit on their power in the name of national security. We do not have enough time today to enumerate all the ways in which the Bush administration has sought to centralize power in the White House. You might say that it would take a book to do justice to that subject. But I've already talked about signing statements, I've talked about dramatically expanded executive secrecy, I've talked about claiming and then demonstrating that a president has the right to bypass laws and ratified treaties governing surveillance and detention. I'll name just a few others. It has claimed and demonstrated that the president has a right to seize and imprison American citizens indefinitely, even when arrested on U.S. soil, without charges or a trial, at the discretion of the executive. As I mentioned earlier, by pulling out of the anti-ballistic missile treaty without asking the Senate to vote on whether to de-ratify it, the Bush administration has locked down a precedent giving presidents the power to dispose of even major ratified treaties at his or her own discretion, an expansion of a precedent that was first established by Jimmy Carter, a great demonstration about why these things are not partisan issues. It is also one from Congress many statutes that add to the president's power. I've already talked about the Patriot Act. After Hurricane Katrina, it won from the Republican Congress a law that allowed the president to impose martial law much more easily, even if a state's governor objects. That measure has been partially rolled back. The only thing, as far as I can tell, that the Democratic Congress was able to roll back that and something to do with the appointment of interim U.S. attorneys in the 2 years after it took power. The Military Commissions Act of 2006, which we heard a lot about today, locked down in statute the president's power to hold U.S. citizens as enemy combatants and expanded the definition of who meets that criteria. Not just suspected members of al-Qaeda, but anyone who is accused of assisting anyone else who is accused of taking up arms against the United States generically. This definition is so broad that it sweeps in the right-wing militia movement, left-wing groups like the Weather Underground, and even the rural mountain dwellers of North Carolina who are suspected of helping Eric Rudolph, the bomber of abortion clinics in the 1996 Olympics, evade federal capture all those years. Not criminals, but enemy combatants. In the Protect America Act and the FISA Amendments Act of 2007 and 8, Congress has locked down the president's warrantless wiretapping program, essentially legalizing the broad spying powers that the administration initially seized on its own initiative. On another plane, the strategy of picking presidential lawyers to fill Supreme Court vacancies has been an integral part of the groundwork this administration has laid for a long-term expansion of White House power. You know, in 2005, when President Bush selected John Roberts Harriet Miers and then Sam Alito to fill the first 2 Supreme Court vacancies in a decade, observers outside the executive branch largely evaluated these nominees through the lens of social issues, like how they were likely to rule on abortion rights. And lost amid the hubbub was what I believe to have been an essential factor behind all 3 nominations. There was a broad array of very prominent, very conservative legal scholars and lower court judges from whom the Bush-Cheney legal team could have selected its nominees. Tellingly, though, the administration chose all 3 times from a very narrow slice of the conservative legal world. All 3 were executive branch legal warriors. As former White House and Justice Department lawyers, all 3 had spent years marinating in disputes over executive power from the president's perspective, pushing for stronger presidential powers. The National Archives houses reams of documents from John Roberts' era in the White House counsel's office in the Reagan administration and Sam Alito's era in the Justice Department's Office of Legal Counsel. Fascinating reading. Roberts pushing for broad Article II powers in the invasion of Grenada, much stronger secrecy powers for the White House, Sam Alito taking an early role in the development of issuing signing statements much more frequently, explicitly as a measure to expand the president's power over law. And of course, Harriet Miers had been part of the Bush administration legal team during all those fights. They had explicitly already embraced theories like the unitary executive. They are thus likely to bring a very deferential attitude to the bench when future lawsuits arise over aggressive claims of presidential authority. Guantanamo-type issues today, but who knows what it'll be 20 years from now. For the most part, the project to expand presidential power has been the most successfully implemented domestic policy of this administration. Only on very rare occasions have there been stumbles. Most notably, as discussed earlier today, in 2006, the Supreme Court's Hamdan decision said that when it came to military commissions, the president must obey a statute passed by Congress and the Geneva Conventions. But the fallout from that ruling was very quickly contained. One-party rule in Congress at the time helped the White House roll back the decision by setting military commissions back up, and much more importantly, I would argue, limiting the ruling's ability to spread by stripping courts of the ability to hear Geneva Conventions-based lawsuits in the future. And, crucially, only 5 of the 9 Supreme Court justices disagreed with the White House's legal theories. The other 4, including Roberts and Alito, are an average of 12 years younger than the 5. And so given the realities of the human lifespan, it seems to me likely that presidents within a few election cycles, if they want to, will have ample opportunity to get that 5th vote. Thus, rather than a final word, the Hamdan decision may turn out to have been something like a last hurrah for the traditional understanding of checks and balances on the president's power in matters of national security.